The Gyanvapi Masjid case is now being heard at a district court in Varanasi, and at this point, this case hinges on a legal concept called maintainability. So in today's episode of KYC, I will tell you how this maintainability application will decide the future of this very controversial case. Now, Order 7 Rule 11 of the Code of Civil Procedure lists down the conditions under which a plaint or a plea can be rejected by the court. Simply put, it helps to determine if the proceedings in a case can continue at all. This rule can be applied at any stage of the case, and it is also called the law on rejection of plaints. And this is what decides whether a civil case or a suit is maintainable at all, that is whether the court can hear it, like I said. The purpose behind this provision is to weed out frivolous pleas to save judicial time and resources. So now, as per this rule, a plea can be rejected on 6 grounds. One of these grounds is a situation where the suit is barred by any law. And this is the subclause that the Gyanvapi Mosque committee has invoked to claim that the Gyanvapi suit is not maintainable in the court in the first place. The committee, Anjuman Islamia Committee, has argued that the suit is not maintainable because it violates the Places of Worship Act 1991. Now let me explain why it says so. Basically, the Places of Worship Act, like I've told you before, was passed during the first year of the P.V. Narasimha Rao government in September 1991, a year before the Babri Masjid was demolished. And this law prohibits conversion of places of worship like, say, churches, mosques or temples to a place of worship of a different religion. It also says that any court proceeding regarding any such conversion would cease after the act comes into force. Along with this, Section 4 of the Act preserves the religious character of a place of worship as it existed on 15th August 1947. The law also says that no suit, appeal or other proceeding with respect to any such matter shall lie in any court, tribunal or any other authority after this law comes into force. And this is the sort of case that Gyanvapi seems to be now. And this is of course a very important law. The Supreme Court in its Babri Masjid Ram Janmabhoomi judgment linked it to secularism, which is a part of the basic structure of the Constitution of India. And as we know, the basic structure of the Constitution cannot be changed even with a constitutional amendment. So basically, the Muslim side is now relying on this law to say that since no suit for changing the religious character of a place or worship is allowed after the 1991 law, this suit deserves to be dismissed. On the other hand, the Hindu side is relying on exceptions under Section 4.3 of this law itself. This subsection lists down 5 situations on which the law won't apply. One of these exceptions is that the law would not apply to any place of worship which is an ancient and historical monument or an archaeological site or anything covered by the Ancient Monuments and Archaeological Sites and Remains Act 1958. So what they're claiming now is that since the erstwhile Kashi Vishwanath temple and the Shringar Gauri temple within the Gyanvapi Masjid complex falls under this 1958 law, therefore it's saying that the 1991 law, the bar under the 1991 law won't apply to this suit. So these are the arguments from both the sides. So now the district court is hearing these arguments specifically on this maintainability issue and will decide whether this case can even be heard by it, can be taken forward by it. Just to let you know, a court in Mathura had undertaken a similar exercise recently. This was in another controversial case in the Krishna Janmabhoomi Shahi Eidgah dispute. This plea has been filed by the Shri Krishna Janmabhoomi Trust and other private parties seeking ownership of the land on which the Eidgah mosque is built. The Eidgah is next to the Shri Krishna Janmabhoomi Sthal, where Krishna is believed to have been born. Just to give you a brief background, the case essentially revolves around ownership of 13.37 acres of land which the petitioners claim belongs to the deity Lord Shri Krishna Virajman. Among other things, the issue here is also the validity of a 1968 compromise agreement between Shri Krishna Janmsthan Seva Sansthan, which is the temple management authority on one hand, and the Trust Masjid Eidgah on the other hand. Through this agreement, the temple authority conceded the contentious portion of the land to the Eidgah on which the mosque stands. So this agreement determined the boundaries of the two structures and both sides had agreed to it. The petitioners and plaintiffs have now challenged the very validity of this agreement. And why I am telling you this is because in this case, the Mathura court has already ruled that the Places of Worship Act is not applicable. Why? Because in this case also the court has taken recourse to one of the 5 exceptions that I told you about. This is exception B, which says that the bar under 1991 law would not be applicable to any matter which was decided, settled or disposed of by any authority before the 1991 law. The court basically relied on older cases which have ruled that the law won't apply to cases where the police demand a declaration for a period prior to 1991 or enforcement of a right which was recognized before 1991. Since this is about a compromise that happened in 1968, the court has ruled that this can be looked into despite the 1991 Act. So basically, this civil suit will now be heard by the court, but the Gyanvapi suit's future still hangs in balance until the court decides on the maintainability. That's all I have for you for now. In this video, we discussed the law on maintainability and also how the Places of Worship Act plays a crucial role in this entire debate. Hope you liked the video. Do let us know in the comments section, and for more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.